The smell of antiseptic hit me before the doors even opened. I remember standing in the hallway of St. Mercy General, still in my work clothes. The kind of Tuesday afternoon where your biggest problem is supposed to be a backed-up inbox. My supervisor had pulled me out of a budget review meeting. Didn't tell me why. Just said my daughter's school called, said there was an incident, said I needed to go to the hospital. That word. Incident. I pushed through the ER doors and I heard my daughter before I saw her. She wasn't screaming. That was the part that broke me. She was just whimpering. This small, exhausted sound, like she'd already been crying so long her body had run out of the energy for it. Lily was 14. She was sitting on a hospital bed with her left arm held against her chest at an angle that arms are not supposed to hold. Her face the color of old paper, and Principal Gerald Marsh was standing 6 feet away from her bed talking to a nurse, laughing about something. Laughing. I didn't know yet what had happened. I only knew two things in that moment. My daughter was hurt, and the man who ran her school was laughing. The nurse noticed me first. I must have looked the way I felt because she stepped slightly to the side, like she was clearing a path. Marsh turned around. He was a big man, 6'2", maybe 250, silver hair, the kind of face that spent 40 years learning how to look trustworthy. He extended his hand. "Mr. Callahan, I'm glad you're here." "There was an unfortunate accident during Don't," I said. I walked past him to Lily. She looked up at me and her chin crumpled, and she said, "Dad, I'm sorry." And I don't know what she thought she had to be sorry about. But I held her good hand and told her she had nothing to apologize for. And I kept my back to Marsh the entire time because if I had looked at him again in that moment, I don't know what I would have done. The ER doctor told me Lily had a fractured radius, clean break, non-displaced, would heal fully with a cast. She also had bruising along her left shoulder and collarbone consistent with, and he chose his words carefully here, blunt impact. When I asked him what that meant, he glanced toward the door, where Marsh was still hovering in the hallway, and he said he would write everything in his report. I stayed with Lily until they set her arm. She fell asleep around 8 from the pain medication. I stepped into the hallway. Marsh was still there. Patient man. He told me what he called the story. Lily had been involved in a confrontation with another student in the gymnasium after school, a pushing incident. She fell against the bleachers. He had witnesses. It was, he said again, an unfortunate accident. He said it the way people say things they've practiced saying. I nodded. I thanked him for coming to the hospital. I shook his hand. Then I drove home, sat in my driveway for 22 minutes, and I let myself remember who I was before Millbrook, Ohio. Before the mortgage and the budget meetings and the Tuesday afternoons. Before I decided, 8 years ago, that I was done. I spent 11 years with the Army's Criminal Investigation Division. The last 4 of those I ran a unit that investigated financial crimes and corruption networks inside U.S. military contracting. The kind of cases that don't make the news. The kind where the people doing the stealing had stars on their shoulders and lawyers on retainer. We didn't work loud. We worked patient. We built cases the way you build a house. Foundation first, everything load-bearing before you add a single wall. I left because my ex-wife said it was the job or the marriage, and I chose the marriage, and then 2 years later she left anyway. But by then I had Lily, and Lily was enough. I had been a quiet suburban dad for 6 years. I drove her to volleyball practice. I packed her lunch with those little notes she pretended to be embarrassed by. I went to every parent-teacher conference and sat in those undersized chairs and listened to teachers tell me she was doing wonderfully. Gerald Marsh had been principal of Millbrook Regional Middle and High School for 9 years. Before that, he was vice principal. Before that, he was a PE teacher in the same district. He had never left. He was the kind of man a small Ohio town decides is an institution, and institutions, people believe, don't do bad things. I knew better than that. The next morning, I called Lily's pediatrician, Dr. Anaya Ruiz, and asked her to see Lily and document the injuries independently. Anaya had known Lily since she was 3. She didn't ask many questions. She got us in at noon. While Lily was with Anaya, I sat in the waiting room and I started making a list on my phone. Not of what I knew, of what I needed to know. I needed to know exactly what happened in that gymnasium. I needed to know who the witnesses were. I needed to know if there had been prior complaints about Marsh. I needed to know what his relationship was with the other student involved. Because Marsh hadn't given me that student's name, and adults who withhold names are usually protecting something. I also needed to know why the school hadn't called 911. A 14-year-old girl with a broken arm, and the school's response was to drive her to the hospital themselves. That detail had been sitting in the back of my head since the night before, quiet and heavy, the way important details always feel before you know why they matter. Anaya's report noted acute fracture of the left radius, significant contusion pattern across the shoulder and upper chest, and something the ER had not flagged. 2 small circular bruises on Lily's upper left arm, consistent with grip marks. Fingers. Someone had grabbed my daughter hard enough to leave the shape of their hand on her skin. She asked me if I wanted her to file a mandatory report with Child Protective Services. I said yes. Then I went home and I called my old colleague Marcus Webb, who had retired from CID 2 years before me and now ran a private investigations firm in Columbus. I didn't need him for his firm. I needed him for his connections and his instincts and the fact that he would pick up the phone on the first ring when he saw my name. He picked up on the first ring. I told him what I had. He listened without interrupting, which is one of the things I had always respected about Marcus. "How bad do you want to go?" he asked when I finished. "All the way," I said. "Then we need a few things," he said. "We need to know if there's a pattern. One incident isn't a pattern. Marsh has been there 9 years. 9 years is a long time to be invisible if you're doing what you're doing." He was right. One case, even a strong one, is a tragedy. A pattern is a crime. Marcus started pulling public records. School board meeting minutes. Incident reports filed with the district. Any civil suits naming the school or its administration. Ohio's public records law is broad if you know how to use it, and Marcus knew how to use it. I focused on the school. I volunteered. I showed up the next week with a sign-up sheet I'd found on the school's website. They were looking for a parent chaperone for the spring academic fair. I introduced myself to the front office staff. I smiled. I asked about parking. I asked which hallway the science classrooms were in. I asked the kind of questions that make you seem like exactly what you appear to be, a concerned parent trying to be involved. What I was actually doing was learning the building. The gymnasium was in the East Wing. The security camera coverage there was a specific kind of bad, not absent, just poorly angled. There was one camera mounted above the main entrance to the gym, but it pointed at the doors, not the interior. Whatever happened inside, near the bleachers, would not be on that footage, but there was a camera in the hallway directly outside. I submitted a public records request to the district for all security footage from the East Wing hallway between 3 p.m. and 5 p.m. on the day Lily was hurt. Schools in Ohio are required to comply within a reasonable time. The district's attorney sent back a letter saying the footage had already been reviewed internally and showed nothing relevant to the incident. They did not say the footage didn't exist. They did not say it had been deleted. They said it showed nothing relevant. I forwarded that letter to Marcus and I called a friend from my CID days who was now an attorney in Cleveland, a woman named Patricia Sohn who had spent the last decade doing civil rights and education law. I asked her what nothing relevant meant legally when you'd submitted a records request. She told me it was a non-compliance response dressed up to look like a response, and that if I wanted to pursue it, she could file a motion in common pleas court within the week. I told her to file. Meanwhile, Marcus had found something. In the 2019 school board minutes, there was a reference to a closed executive session regarding a personnel matter in school administration. No names, no details. Executive sessions are shielded, but attached to the minutes was a line item in the district's financial report, a $47,000 settlement paid by the district's liability insurance carrier to an unnamed party. $47,000. In a school district with an annual budget of $11 million. Not enormous. Not nothing. I asked Marcus to go back further. He went back to 2016. There was another one, $31,000. Same structure, executive session, liability carrier, unnamed party. 2 settlements in 8 years. Both during Marsh's tenure. Both buried in budget footnotes. I thought about what those numbers meant. I thought about the families who had taken those settlements. I thought about the non-disclosure agreements they had almost certainly signed. And I thought about how non-disclosure agreements make institutions feel safe and make victims feel alone. And I thought about how many parents in Millbrook had driven past that school every morning and never known. I had a harder conversation with Lily that week. I sat on the edge of her bed while she was doing homework with her cast propped on a pillow, and I told her I needed to know exactly what happened. Not the version she'd told the school nurse. Exactly what happened. She was quiet for a long time. Then she told me that she and a boy named Tyler Marsh, Gerald Marsh's son, had gotten into an argument about a group project. That Lily had told Tyler she was going to go to the teacher because he hadn't done his portion of the work. That Tyler had told her if she said anything, his father would make sure she regretted it. That she'd laughed at him because she thought he was just being dramatic. That Principal Marsh had appeared in the gymnasium that afternoon when most of the other students had already left, and he had told her that she had a problem with her attitude, and that her problem had consequences, and that he expected her to be more careful in the future. And then he'd grabbed her by the arm. She had pulled away and stumbled backward into the bleachers. That was how her arm broke. I kept my voice completely steady. I told her she did nothing wrong. I told her she was the bravest person I knew. I told her she was the bravest person I knew. I told her to get some sleep. I went downstairs. I sat at my kitchen table, and I did not sleep for a long time. The thing about investigating someone is that the work doesn't feel like revenge. It doesn't feel like anything, actually. Not when you're doing it right. It's just measurement. You measure distance. You measure gaps. You measure what should be there against what is there, and you follow the difference wherever it goes. I had followed the difference for 11 years in rooms far uglier than a suburban kitchen. I knew how to be patient. Patricia filed the motion for the security footage. The district's attorney responded by claiming the footage had been recorded overdue to the system's standard 30-day retention cycle. The incident had occurred 28 days before our request. 2 days inside the window. An extraordinary coincidence. Patricia filed a motion for spoliation of evidence. That is a legal term for the destruction of evidence that was, or should have been, preserved. Ohio courts take it seriously. The district's attorney suddenly became more interested in talking. While that worked its way through the court, Marcus had been making discreet phone calls. He had tracked down a woman in Dayton who had briefly been a guidance counselor at Millbrook Regional in 2018 before leaving abruptly. She wouldn't talk on the record. But she talked. She told Marcus that she had filed an internal complaint about Marsh following an incident where she witnessed him physically restrain a student, a boy, in a way she described as excessive and humiliating. She was told by the assistant superintendent that she had misinterpreted the situation. 3 months later, her contract was not renewed. She had not taken a settlement. She had just left. She had a daughter in college and couldn't afford a legal fight. "Why are you looking into this now?" she asked Marcus. "Because someone finally can," he told her. The motion for spoliation worked in a way I hadn't anticipated. Under the pressure of discovery, the district's IT contractor, a private company called Apex Technology Solutions, produced logs showing that the security system had been manually accessed on the evening of the incident, not by the automated retention cycle, by a user with administrative credentials. Those credentials belonged to Gerald Marsh. He had gone into the security system himself, the night my daughter's arm broke, and he had deleted the footage from the East Wing hallway. Patricia sent me the IT logs, and I read them 3 times. Then I called the Millbrook Police Department's non-emergency line and asked to speak to whoever handled criminal referrals. I was transferred to a detective named Ruiz, no relation to Anaya, who listened to what I had and told me he would look into it. I told him I had documentation. I told him I had a forensic chain. I told him I would walk him through every piece of it at his convenience. He met me at his desk the next morning. I had worked with law enforcement for 11 years. I knew how to brief a detective. I came in with a physical binder, indexed, tabbed, chronological, and I talked for 40 minutes without editorializing. Just facts, documents, dates, sources. Detective Ruiz was not a bad investigator. He asked good questions. He asked about the IT contractor's methodology and whether the log timestamp could be spoofed. I told him the contractor had already been asked that question and had provided the hash verification to confirm integrity. He looked at the binder. He looked at me. "What did you do before Millbrook?" he asked. "I was Army CID," I said. "Financial crimes and corruption. 11 years." He nodded once, slowly, the way people nod when something that felt complicated suddenly feels simple. The school board voted to place Marsh on administrative leave 12 days later, pending investigation. The vote was 6-1. The one dissenting vote was a board member whose son had played football with Tyler Marsh in high school. The county prosecutor's office filed criminal charges against Gerald Marsh 6 weeks after that. Felonious assault, a second-degree felony in Ohio carrying 2 to 8 years. Tampering with evidence. Intimidating a witness. Stemming from what the investigation uncovered about 2 additional students Marsh had approached in the weeks after the incident and told in various ways to keep quiet. Those students came forward once Marsh was on leave. There were 4 of them total when everything surfaced. 4 kids over 9 years who had been grabbed, shoved, cornered, or physically intimidated by a man who ran their school. 4 families who had either been paid off or scared off or simply not believed. The settlements, the personnel complaint, the missing footage, 9 years. I think about that number sometimes. 9 years of a man walking those hallways, and every single morning a new group of kids walking in who didn't know, whose parents didn't know, who had no reason to know. Because institutions protect institutions, and small towns protect the people who feel permanent. I testified at the preliminary hearing. I testified about the documentation, the IT logs, the records requests. Patricia had me walk through the timeline twice. Once for the judge, once for the record. Marsh sat at the defense table in a gray suit that probably cost more than my first car, and he looked at the wall behind me the entire time I spoke. He did not look at me once. His attorney tried to characterize my investigation as a vendetta. A scorned parent who had gone rogue. Patricia objected and was sustained. I was asked on cross-examination whether I had any formal law enforcement authority in Ohio. I said no. I was asked whether any of my investigative activity had compromised the chain of custody for any evidence. I said no, and I said why, in specific terms that I could tell the defense attorney had not expected. He moved on. The assistant superintendent, a woman named Diane Fowler, was charged separately with obstruction of justice for her role in discouraging the 2018 guidance counselor's complaint and for her communications with Marsh in the days following Lily's injury. Communications that the IT forensics had also surfaced from the school district's email servers. She accepted a plea agreement, 1 year of supervised probation, mandatory removal from her position, and permanent prohibition from working in an administrative role in Ohio public education. I will be honest, when I heard the terms of her deal, I sat with it for a day. It was not nothing. Losing a career you built over 20 years is not nothing. But I thought about the guidance counselor in Dayton, and the 3 months she'd spent working under a man like Marsh while she was trying to decide whether to trust her own eyes. I thought about what it costs a person to speak up and be told she was wrong, and then be let go. I thought about what it costs a person to just quietly leave, because the fight is too big and the support is too small. The plea agreement stood. It was not the outcome I would have written, but it was the outcome the law produced, and I am not interested in replacing the law. I spent 11 years working inside it, and I know it is imperfect, and I know it is still better than the alternative. Marsh's trial is scheduled for later this year. His attorney has filed 3 continuance motions. The case is strong. Patricia does not express uncertainty she doesn't have, and she is not expressing uncertainty. Lily got her cast off in March. She's doing physical therapy for her shoulder. She went back to school in January 2 weeks after Marsh's leave began, and I walked her to the front door on her first day back. She told me not to walk her to the door. She said she was 14, not 7. I walked her to the front door. She rolled her eyes at me the way she does. The way that means she's okay. The way I have learned to read after 14 years of being her father. And she walked in. And I stood there on the sidewalk in February, cold, watching the door close behind her. And I thought, that's the whole job. That's the entire thing. You make sure they can walk through the door. I drove home. I have been asked a few times since everything became local news whether I am angry, whether I feel vindicated, whether this changed something for me about how I see the systems that are supposed to protect kids. The honest answer is that it didn't change anything. I already knew how those systems work. I knew that institutions are not designed to protect the vulnerable. They're designed to protect themselves. And sometimes those two things overlap, and sometimes they don't. And the difference depends entirely on who is paying attention and whether that person has the tools to do something about it. I had the tools. I had them because of 11 years that cost me a lot and gave me a lot. Most parents don't have those tools. Most parents sit in that ER hallway and they hear the word incident and they have no idea what to do next. They call the school. They ask for an explanation. They accept the explanation because the man giving it has a title and a suit and 9 years of being considered an institution. That part keeps me up sometimes. Not the case. The case is where it is. What keeps me up is the before. All the years before. All the other hallways. All the parents who didn't know and were never going to know. Lily asked me recently if I ever missed my old job. We were at the kitchen table, a Saturday morning, and she was doing some kind of art project that involved a quantity of glitter I would be finding in this house for the next decade. I told her sometimes. She looked up at me, glitter on her nose, and she said, "Did you do stuff like this? Like figure things out?" I told her yes. That was most of it, actually. Figuring things out. She thought about that for a second. Then she went back to her project and said, "Good. I'm glad you knew how." I didn't say anything. I just sat there and watched her work. And I thought about a Tuesday afternoon in February, and a hospital hallway and the sound of a man laughing. And I thought about how the distance between that moment and this one was not luck, was not fate. Was not justice falling from the sky the way it never actually does. It was patience, and documentation, and the willingness to go all the way. That's what it takes, that's what it always takes. If your child comes home and something is wrong, something they can't name, something in how they hold themselves, something in how they go quiet in ways they didn't go quiet before, trust that. Document everything. Get independent medical opinions in writing. Learn your state's public records laws. Find out who in your community has dealt with this before you. And if the people who are supposed to protect your child tell you there is nothing to see here, that it was an accident, that you are overreacting, remember that institutions say that. That's what institutions do. You don't have to have 11 years of CID training to push back. You just have to be willing to keep pushing. I am my daughter's father. That has always been the most important thing I am. Everything else, the training, the experience, the patience, all of that was just preparation for the moment someone decided that didn't matter. They were wrong about that. People like that are always wrong about that. People ask me sometimes what the hardest part was. They expect me to say the ER. They expect me to say the night Lily told me the truth. What actually happened in that gymnasium? Who actually grabbed her? Why her arm was broken at an angle that arms aren't supposed to break. And those moments were hard. I won't pretend otherwise. But the hardest part was the 48 hours before I did anything. When I was still just a dad sitting at a kitchen table trying to decide whether the version of myself I put away 8 years ago was someone I was allowed to be again. I had built a quiet life on purpose. I had made a choice. After 11 years of watching what institutions do when they feel threatened, to step back, to drive my kid to volleyball practice and pack her lunch and sit in undersized chairs at parent-teacher conferences. I had decided that was enough, that I had done my part and now I could just be a father. Gerald Marsh made that decision for me. What I've come to understand, not just from this but from 11 years before this, is that men like Marsh don't become what they are overnight. They become it slowly. in rooms where no one is paying attention, in the small moments where someone could have spoken up and didn't, where a complaint was filed and then quietly buried, where a settlement was paid and a family signed a piece of paper that said they would never speak about it again. That's how it works. Not one explosion, 1,000 small silences. The guidance counselor in Dayton, who filed her complaint in 2018 and was told she was wrong and then lost her job, she wasn't weak, she was alone. There is a difference. She did the right thing and the system closed around her like water over a stone. She left because she had to, not because she gave up. I think about her a lot. I think about what it costs a person to trust their own eyes and then be told by people with authority that their eyes lied, and then to carry that for years. What I did wasn't courage. I want to be clear about that. I had tools she didn't have. I had training and contacts and 11 years of knowing exactly which documents to request and exactly how institutions respond when they feel the ground shifting. I had Marcus. I had Patricia. I had, frankly, the kind of patience that only comes from having done this work long enough to know that cases don't break in a day. They build, and then they break all at once, and you have to be willing to stay in the building phase as long as it takes. Most people can't do that. Most people shouldn't have to. What Lily taught me, without knowing she was teaching me anything, is that the most important thing I could model for her wasn't what I did in those 11 years. It was what I did after. It was the decision to look at something wrong and not look away from it just because looking at it was hard. That's the whole thing. That's the part that matters. Not the training, not the binder, not the motion for spoliation of evidence. The decision to not look away. She walked back through those school doors in January and she rolled her eyes at me for walking her to the entrance. And that eye roll was the best thing that happened to me in a very long time. Because it meant she was okay. It meant she was still herself. It meant that what Marsh tried to take from her, her sense that the world was a place where someone would fight for her, was still intact. That's what it's for. All of it. Every piece of it. You protect your kids so they still believe the world is worth walking into.